Did he commission his affidavit?
Yes.
Okay,
The
good.
original, you have a copy that's
It's fine. I don't have a problem as long as the court has the signed one.
commission.
Okay.
Is it?
All right.
You look silent.
I hope so. I will do that. I'll check this now. I'm just checking a whole lot of other things. This is case number RC 38 of 2026 before the presiding officer, Mrs. Sicheche, the state Mapalala, assisted by Advocate Mpahlele, our interpreter, Mr. Mvindaba, Advocate Muhumani for the accused, and our clerk of course is Ms. Masemula and Mrs. Dlamini. Your Worship, I'm trying to attach the application by the media on the charge sheet. I don't know where exactly. I'm going to leave it with the clerk of court. She will attach it later on, because I don't know which part where it's supposed to go. Before Your Worship, we start with today the matter was postponed to today for a bail application. The matter was transferred from the district court to the regional court for the purposes of bail. We have in the charge sheet the certificate in terms of section 60, subsection 4, by the Director of Public Prosecution directing that the matter be heard here in the regional court for bail. Before we proceed with the bail, before I do that, both the state and the defense are ready to proceed. Advocate, confirm.
Please respond, Your Worship. I confirm submissions made by my learned friend from the state. It is indeed correct, Your Worship, that both parties are ready to proceed with the bail application.
Your Worship, before we proceed, there was an application that was made in chambers regarding the presence of the media in court to record the proceedings. May the court, just for the purpose of the record, read out the order that it has made. Oh, sorry.
Okay, the order is that the proceedings in court to be televised, to be broadcast, to be taped, photographs to be taken in court during recess, immediately prior to court sessions, after court sessions, television cameras to be used in court during court sessions, during recess, immediately prior to court sessions and after court sessions, subject to the following conditions, that no equipment or material be moved, reloaded or otherwise tampered with during the court sessions, and that the presiding officer's photographs not to be taken and not to be televised. Thank you.
Namhlanje ke Mr. Matipandile Sotheni sizawumamela ke isicelo sakho sokuxoxela ityala ngaphandle njengoba ke umtshutshisi elitshilo ngaphambili into yobana benikhe neza ekundleni kwacelwa ke into yoba lihlekiswe icala okanye limiswe icala lisuswe kwelaa cala lala nkundla iphantsi liziswe kule nkundla yase-regional court khona ukuze kuzomangelwa icala lakho. Futhi ke kukhona isicelo esikhoyo sento yobana ke oonomathotholo ke kwakunye noomabonakude babe khona bashicilele icala njengoba sizaqhubeka court cases.
Your Worship, before we proceed, the court did not make any order in respect to the face, or rather the faces, yes, of both the defense and the state, not also to be shown on TV. We did discuss that with the colleague and we do agree.
Thank you.
Yes, please.
Copies, Your Worship, I do confirm submissions.
Thank you. Can the advocate Mphahlele then confirm the church's preferred so that we are able to implement the schedule?
Your Worship, the accused is facing how many counts? 16 counts before this court. That is the number 1, conspiracy to commit murder. Number 2, murder, right with section 51(1), schedule 2, part 1 of the Criminal Amendment Act 105 of 1995. 3 counts of attempted murder, possession of unlicensed firearms, and unlawful possession. Must I say it one by one, which count? We also have a possession count of theft. Now I'm going to start with count 1. Count 1 is conspiracy to commit murder in contravention of section 18, subsection 2, subsection A of the Notorious Assemblies Act 17 of 1956, right with the provision of section 51(1) of the Criminal Law Amendment Act 105 of 1997, that is conspiracy to commit murder. In that during the period November to December 2025, at near Gauteng province, the district of Gauteng, the accused unlawfully intentionally conspired with Willem Viandre Pretorius, who is now deceased, and other known and unknown persons to the state to aid or procure the commission of or to commit an offense to which it was murder by conspiring to unlawfully intentionally killing Marius van der Merwe, an adult male person. Second count is that one of murder, right with provision of section 51(1), right with part 1, schedule 2 of Act 105 of 1997 as amendment, in that upon or about the 5th of December 2025 at near Hout Street, Brenthurst, Brakpan, in the district of Brakpan, the regional division of Gauteng, the accused and or together and or in the furtherance of a common purpose did unlawfully and intentionally kill Marius van der Merwe, an adult male person, by shooting him with a firearm. Attempted murder, in that upon or about the 5th of December 2025 out near Hout Street, Brenthurst, in the district of Brakpan, the regional division of Gauteng, the accused and or together and or in the furtherance of a common purpose intentionally attempted to kill the following persons: Leanne Maria McLean, an adult female; Grayson McLean, a minor child; Oliver McLean, a minor child, who were seated inside a vehicle in a driveway of their residence at the time of the shooting the deceased Marius van der Merwe by discharging an AK-47 rifle from a motor vehicle in close proximity to the motor vehicle where the deceased was shot and killed. The state will allege that the accused foresaw the possibility that the discharge of a firearm. Oh, my apologies, Your Worship, I completely forgot about Mr. I will give you a copy of the indictment, of the charge sheet when I'm done. My apologies, I completely forgot. The state will allege that the accused foresaw the possibility that the discharge of a firearm in close proximity to the motor vehicle occupied by the said Leanne Maria McLean, Grayson McLean, Oliver McLean could result in them being struck by a bullet or bullet fragments, including by way of ricochet, thereby creating a real or substantial risk of death to the occupants of the vehicle, and nevertheless reconciled himself with that possibility and proceeded with such conduct by demonstrating a reckless regard for human life. Count 6, contravention of section 3, read with section 1, 103, 117, 120, read with the schedule 4 of section 151 of Firearms Control Act 60 of 2000, further read with section 250 of the Criminal Procedure Act 51 of 1977, that is unlawful possession of a firearm, in that upon or about the 5th of December at or near Hout Street, Brandhurst, Brakpan, in the Regional Division of Gauteng, the accused did have in his possession an AK-47 automatic assault rifle or of a similar caliber rifle without holding a license or a permit or authorization issued in terms of the said act to possess that firearm. Count 7, the contravention of section 90, read with section 1, 103, 117, 120, subsection 1, subsection A, section 121, read with schedule 4, section 151 of the Firearms Control Act 60 of 2000, and further read with section 250 of Criminal Procedure Act 51 of 1977, that is unlawful possession of ammunition, in that on about the 5th of December 2025 at or near Hout Street, Brandhurst, Brakpan, in the Regional Division of Gauteng, the accused did unlawfully have in his possession the following ammunition. It was an unknown number of AK-47 automatic rifle ammunition without being holder of a license in respect of the firearm capable of discharging that ammunition, B, a permit to possess that ammunition, C, a dealer or manufacturer's license or gunsmith license, import, export, or transit permit or transporter's permit issued in terms of the Act, or is otherwise authorized to do so.
Sorry. Mr. Sotheni, can you miss it?
Count 8, contravening of section 90, right with section 1, 103, 117, 120, subsection 1, subsection A, section 121, right with schedule 4 of section 151 of Firearms Control Act 60 of 2000, and further right with section 250, Criminal Procedure Act 51 of 1977, unlawful possession of ammunition, in that about the 14th of March 2026, at or near 10, Unit 10, Beverly Hills, Basonia in Joburg, in the Regional Division of Gauteng, the accused did unlawfully have in his possession the following ammunition. To wit, it was 125 rounds of R5 rifle ammunition without being the holder of a license in respect of the firearm capable of discharge that ammunition, a permit to possess that ammunition, a dealer or manufacturer's license, gunsmith license, import, export, or transit permit, or a transporter's permit issued in terms of the Act, or otherwise authorized to do so. Count 9, contravention of section 90, right with section 1, 103, 117, 120, subsection 1, subsection A, section 121, right with section schedule 4 of section 151 of Firearms Control Act 60 of 2000, and further right with section 250 of the Criminal Procedure Act 51 of 1977, unlawful possession of ammunition, in that or about the 14th of March 2026, at or near Unit 10, Beverly Hills, Johannesburg, in the Regional Division of Gauteng, the accused did unlawfully have in his possession the following ammunition: 31 rounds of R1 rifle ammunition without being the holder of a license in respect of the firearm capable of discharging that ammunition, a permit to possess that ammunition, a dealer's or manufacturer's license, gunsmith's license, import, export, or transit permit or transporter's permit issued in terms of the Act, or otherwise authorized to do so. Count 10, contravention of section 90, right to section 1, section 9, count 10, contravention of section 90, right to section 1, 103, 117, 120, subsection 1, subsection A, 121, read with Schedule 4 of Section 151 of Firearms Control Act 60 of 2000, further read with Section 250 of the Criminal Procedure Act 51 of 1977. That is unlawful possession of ammunition. In that, on or about the 14th of March 2026, Your Worship, application to amend the charge on count 10 is 2026 instead of 2025. That is on the 14th of March 2026.
Any objection from the defense?
On the amendment for the year, none motion.
Thank you. Duly amended. 14 March 2026.
2026, as court pleases. In that, upon about the 14th of March 2026, at or near Unit 10, Beverly Hills, Johannesburg, in the Regional Division of Gauteng, the accused did unlawfully have in his possession the following ammunition: 17 rounds of a 9mm parabellum pistol ammunition without being the holder of a license in respect of the firearm capable of discharging that ammunition, a permit to possess that ammunition, a dealer's or manufacturer's license, gunsmith license, import, export, or transit permit, or transporter's permit issued in terms of the Act, or otherwise authorized to do so. Count 11, contravention of Section 120, subsection 8, subsection A, read to Section 1, Section 117 of Firearms Controls Act 60 of 2000. Also read with the provisions of 86 of 2004, that is Firearms Control 2004, GNR 345, that is failure to safeguard ammunition. And that upon about the 14th of March 2026, at or near Unit 10, Beverly Hills, Johannesburg, in the Regional Division of Gauteng, the accused, being a license holder of firearms, did unlawfully and or negligently fail to store ammunition in accordance with the provisions of the Act. And whereas the ammunition was found in his premises, that is in the kitchen, it was 125 rounds of an R5 rifle ammunition. Count 12, contravention of Section 120, subsection 8, subsection A, right to Section 117 of Firearms Control Act 60 of 2000. Also read with Regulations 86 of 2004, that is Firearms Control Regulation 2000, GNR 345, failure to safeguard ammunition. In that, upon about the 14th of March 2026, at or near Unit 10, Beverly Hills, Johannesburg, in the Regional Division of Gauteng, the accused, being license holder of a firearm, did unlawfully and or negligently failed to store ammunition in accordance with the provisions of the Act, and whereas the ammunition was found in his premises and or in the kitchen, it was 31 rounds of an R1 rifle ammunition. Count 13, contravention of Section 120, subsection 8, subsection A, right to Section 1, Section 117 of Firearms Control Act 60 of 2000, also read with Regulations 86 of 2004, that is the Firearms Control Regulation 2004, GNR 345, failure to safeguard ammunition. In that, upon about the 14th of March 2026, at or near Unit 10, Beverly Hills in Joburg, in the Regional Division of Gauteng, the accused, being a license holder of firearms, did unlawfully and or negligently fail to store ammunition in accordance with the said provisions. Whereas the ammunition was found in his premises, it was 17 rounds of a 9mm pistol ammunition. Count 14, contravention of Section 120, subsection 8, subsection A, right to Section 1, Section 117 of Firearms Control Act 60 of 2000. Also read with Regulation 86 of 2004, that is Firearms Control 2004, GNR 345, failure to safeguard ammunition. In that, upon or about the 14th of March, at or near Unit 10, Beverly Hills, Johannesburg, in the Regional Division of Gauteng, the accused being a licensed holder of firearms did unlawfully and or negligently fail to store ammunition in accordance with the provisions of the Act, whereas the ammunition was found in a premises and or in the lounge. It was 4 rounds of a .308 caliber rifle ammunition. Count 15, contravention of section 120, subsection 8, subsection A, read with section 1, section 117 of Firearms Control Act 60 of 2000, also read with regulation 86 of 2004, that firearms control, 2004, GNR 345, failure to safeguard ammunition, in that upon about the 14th of March 2004, 14th of March, apologies, Worship, in that upon the 14th of March 2006, at or near Unit 10, Beverly Hills, Johannesburg, in the Regional Division of Gauteng, the accused being a license holder of firearms did unlawfully and or, may I just read again, count 15, Your Worship.
Yes.
Application to correct, it's not firearms, but it's holder of a firearm. It's written in plural, firearms. In that upon the 14th of March 2026, at or near Unit 10, Beverly Hills, Johannesburg, in the Regional Division of Gauteng, the accused being a license holder of a firearm did unlawfully and or negligently fail to store a firearm in accordance with the provisions of the Act. And whereas the firearm was found in the premises and or in a lounge behind a sofa, to this was a .308 caliber rifle. And count 16, that is theft, in that upon the dates unknown to the state at or near Joburg in the Regional Division of Gauteng, the accused, again, application to amend, the accused was written twice instead of one, in that the accused did unlawfully and intentionally appropriate property belonging to the South African police and or the state, to which it was 195 rounds of a R5 rifle.
125.
What did I say? Okay, may I just read again?
Yes.
In that upon, on the dates unknown to the state, and at or near Johannesburg in the Regional Division of Gauteng, the accused did unlawfully and intentionally appropriate property belonging to the South African Police Services and or the state. To it was 195 rounds of an R5 rifle ammunition, 31 rounds of R1 rifle ammunition, 17 rounds of 9mm parabellum pistol ammunition. The accused intended to deprive the South African Police Service and the state the control and or ownership over such property. Those are the charges that the state is preferring against the accused.
Ukuzama ukwenza icebo lokuzama ukubulala usebenzisana ke novelem Victorious ongaziwayo ke okwangoku izama ke ukubulala uMarius van der Merwe. Uthi ke icala ke lesibini licala ke okanye ityala lokubulala uMarius van der Merwe, atsho ke echaza ithi ngomhla wesihlanu kuDisemba ka-2025 nakwindawo yase Hart Street Bentest la eBrakpan, kuthi ke kule ndawo ilapha ke kwesisithili sale nkundla yaseBrakpan, kuthi ke kwena ke kwakunye nalo umuntu ungaziwayo nobabini nabulala ke wena ke uMarius van der Merwe ongumuntu oyindoda osekhulile, ngokuthi ke kwamdubula ke ngompu. Uthi ke elesithathu ityala otyatye kwalona lityala lokuzama ukubulala. Uchazwa ke abantu abathathu apha, kuthiwa ke nguLeon McLean ongumuntu ongumama omdala, kwakunye ke noGrayson McLean ongumntana kwakunye no-Oliver McLean naye okwangumntana. Kuthiwa ke wena ke uMarius van der Merwe lo wayeqhuba ke imoto wama ke kule ndlela izawungena apha endlini. Apho ke wena ke waye ke wamdubula ngompu okubizwa ngoba yi-AK-47 ke lo mpu lowo kuthiwa ke wawudubula ke wena ke ideli emotweni kwaye usondele kakhulu kuye uthi ke wamdubula ke waze wafa yena ke kweli tyala lokuzama ukubulala liphantsi kwamatyala amathathu ngoba abantu bathathu iwenzeke loo matyala afike phaa kwisihlanu. Ityala ke lesithandathu kuthiwa ke lityala lokufunyanwa umpu lowo ke kuthiwa ke yi-AK-47 umtshini ozitshintshayo kwakunye ke okanye ke bathi ke into engathi ifana ne-AK-47 futhi ke ungenayo impepha mvume yokuphatha umpu onjalo. Kuthiwa ke ityala lakho lesixhenxe lityala ke lokufumaneka ke ngokungekho mthethweni uneembumbulu ezingabalwanga ukuba zingaphi zayo yona uzawona lo mpu kuthethwa ngawo okuthiwa yi-AK-47 futhi ke nazo ezo mbumbulu kungenawo amaphepha wazo futhi kungekho nento ekuvumelayo uba ube kanti uziphethe ngelo xesha. Kuthiwa ke ityala lakho lesibhozo obekwa lona lityala nalo lokufumaneka uneembumbulu apha kuwe ngomhla ke we-14 zikaMatshi kulo nyaka sikuwo. Kuthiwa ke wafumaneka uneembumbulu ezibalelwa phaa kwikhulu elinamashumi-25. Kuthiwa ke ezo mbumbulu ziimbumbulu zompu obizwa ngokuba yi-R5. Kuthiwa ke nalapho kwafumaniseka into yoba awunawo amaphepha okuphatha lo mpu unjalo kwakunye ke nazo zona iimbumbulu ezizinjalo. Akukho nento ekuvumelayo okanye nomntu oyithengisayo le mpu okuvumelayo uba ungaphatha impu efana naleyo okanye ke iimbumbulu ezinjalo. Kuthiwa ke ityala lakho futhi ke elinesithoba kuthiwa ke lityala lokufumaneka futhi unazo iimbumbulu. Kuthiwa ke kwangalo mhla we-14 zikaMatshi ngo-2026 kuthiwa ke wafumaneka neembumbulu ezingama-31 zompu obizwa ngohlobo le-R1 irifle nayo. Kuthiwa ke kwakufumaniseka into yobana ubungenawo futhi kwa iimpepha mvume zokuphatha iimbumbulu ezinjalo okanye kwa into ekuvumelayo ube kanti uphethe iimbumbulu ezinjalo. Ityala lakho ke leshumi futhi kwafumaneka neembumbulu kuthiwa ngomhla we-14 zikaMatshi ngo-2025 kuthiwa ke kwafunyanwa iimbumbulu ezili-17 zompu obizwa ngoba yi-9mm iparabellum ipistol ke ngokutsho. Futhi ke kufumaniseka into yobana ungenayo ilayisensi yokuphatha umpu onjalo, ungenawo futhi namaphepha mvume wokuphatha umpu ofana nalowo. Futhi ke ityala lakho le-11 kuthiwa lityala ke lokungakwazi ukuqoqosha umpu okanye isikhali esifana nompu okuthiwa ke ukusafeguarda izinto ezifana nanjezo ngoba kuthiwa ngomhla we-14 zikaMatshi kwanjalo kuthiwa ke wafumaneka ke kwakhona neembumbulu eziqikelelwa phaa kwikhulu elinama-25 lo mpu obizwa ngokuba yi-R5 irifle choko. Nokuthi ke ityala lakho ke le-12 lityala lokungakwazi ukugcina ngokuphephileyo umpu ngoba kuthiwa ke ngomhla we-14 zikaMatshi ngo-2026 kwafumaneka ke iimbumbulu eziyi-31 nazo ke zombumbulu zingama-31 kuthiwa zezohlobo le-rifle le kuthiwa yi-R1 nazo zafumaneka kanjalo kuwe. Nokuthi ke ityala lakho le-13 nalo ityala lokungakwazi ukugada okanye ukusikalisa ngendlela eyiyo umpu ngoba kuthiwa ngalo mhla we-14 zikaMatshi ngo-2026 kwaye kwafumaneka ke iimbumbulu eziyi-17 zompu ekuthiwa ke yi-9mm iparabellum ipistol zifumaneka ke zona ke ekhitshini apho ke uhlala khona ngoba ke kuchaziwe apha ke indawo kuthiwa kuse-Unit 10 eBeverly Hills eJohannesburg. Kuthiwa ke indawo engaphaya kulela cala lase-Regional Division yase-Gauteng ke apho ke wafumaneka nezo zinto futhi ke ungenayo ilayisensi noma into ekuvumelayo uba ube kanti uyaziphatha umpu onjalo. Ityala lakho ke otyake kwalona le-14 kuthiwa ke ukukhohluleka futhi ukugcina ngendlela eyiyo kuba kuthiwa ngalo mhla we-14 zikaMarch ngo-2026 kwakule ndawo yase-Unit 10 eBeverly Hills eGauteng kuthiwa-ke kwafumaneka-ke iy'mbumbulu ezine zohlobo lwe-308 caliber irifle leyo kuthiwa-ke zafumaneka nazo apho-ke kuleyo ndawo wawubanjelwe kuyo-ke e-10 Beverly Hills eJohannesburg. Kuthiwa-ke ngomhla ityala lakho le-15 nalo ityala lokungakwazi ukuphatha kakuhle-ke izixhobo ezifana nokuthiwa ngomhla we-14 zikaMarch ngo-2026 kwakuyo i-Unit 10 eBeverly Hills apha eJohannesburg kuthiwa-ke apho-ke nawe-ke wafumaneka-ke emveni kwesofa kwafumaneka umbu-ke olwehlobo lwe-308 okanye-ke kwafumaneka uhlobo lompu we-308 caliber rifle emveni kwesofa. Kuthiwa-ke ityala lakho lesithathu lityala-ke lokuba apho-ke kuthiwa-ke waba wena-ke iimbumbulu ezikhulu-125 ezohlobo lwe-R5 irifle ke leyo nezinye imbumbulu ezingama-31 zohlobo le-R1 irifle nezinye-ke ezili-17 zohlobo le-9mm ibhazo ispolisa salapha eMzantsi Afrika i-South African Police Services. Ukutsho oko kuthiwa-ke wena-ke injongo zakho ibikuzithatha unomthelo apha-ke kweli candelo lesipolisa. What please is your worship.
Attached to the charge sheet is a certificate in terms of section 60, subsection 11, capital A of the Criminal Procedure Act of 1977, which determines that the offense under paragraph 2, that is the murder, is listed in schedule 6 of the Criminal Procedure Act, and the state to allege that the offense was committed by a person or group of persons, syndicate or any enterprise in acting in execution and furtherance of the common purpose or conspiracy, and that therefore these bill applications should proceed in terms of section 60, subsection 11A, as schedule 6 bill application, as the defense confirmed.
We do confirm that she has the consequences.
Thank you. And the defense is ready to proceed.
Thank you, Your Worship. Prior to proceeding with the bail application, I wish to bring on record that the charge sheet that we have from the state is the one that was sent by email on the 14th of April, which was the initial charge sheet that has 7 charges to it. The defense has not been privy to the charge sheet that contains 16 charges. Upon listening and perusal of the charge sheet, Your Worship, if I may, we have a charge sheet that contains the following charges. One is that of conspiracy. The second is that of murder. The third, fourth, and fifth is that of attempted murder of the 3 victims that have been mentioned by the state. The sixth charge is contravention of section 3. It's unlawful possession of a firearm, which is the AK-47. The seventh charge is that of ammunition in the form of R5 ammunition, 125. R1 ammunition in the quantity of 31. And 17 9mm parabellum firearm ammunition.
Okay, is count 1 to 6 as per the current charge sheet.
It's count 1 to 7, count 1 to 7, Your Worship, of the initial charge sheet. There was mention on the previous occasion that other charges would be added. I submit that I believe that it's not malice on the part of the state not to finish the amended charge sheet. It's probably an oversight. When I didn't receive it, I had thought to myself that we are confining ourselves to 7 charges as per the initial charge sheet. I wish to emphasize that point, that it's not malice on the part of the state. Mention was made thereof. Now, what has then transpired, Your Worship, is that we do have a bail application which we have prepared for a bail affidavit, I apologize, which we have prepared for the application. We are amenable to proceed, however, we request leave that we be given an opportunity at a later stage to supplement our papers in order to answer from count 8 to count 16 of the amended charge sheet, and that the state provide us with a copy of the amended charge sheet.
Mfoka Sotheni, ummeli wakho ke uyashukuma naye ke uchazela inkundla into yokubana ke thina ke amatyala esiwaziyo nesiwalungiselele amatyala asiqhele ebebekwe kuwe, amatyala ke eli tyala lozama ukuquluma ukubulala, netyala lesibini lokubulala, namatyala amathathu okuzama ukubulala, kwakunye ke netyala lokufumaneka ke ngokungekho semthethweni unesibhamu ke sohlobo le-AK-47. Ityala lesine, ityala lesixhenxe ke ityala lokufumaneka ke unembumbulu zohlobo le-R1 ezi-125, kwakunye ke nembumbulu zohlobo le-R1 ezingama-31, kwakunye netyala lembumbulu ezili-17 lohlobo lwe-parabellum. Esitsho ke into yobana ibike yachazwa apha ke ngumtshutshisi into yobana bangawafaka amanye amatyala ekuhambeni kwexesha, kodwa ke akubadanga bayenza loo nto bade bafikelele ixesha lanamhlanje. Uthi uyeva ke into yobana la matyala sefakiwe, ngoba ke bebetshilo into yoba amatyala bazawongeza bawafake apha kula matyala wakho. Uthi ke sizawucela into yobana ke sikulungele ngokuba singayixoxa nisimamele isicelo sethu sokukhutshwa uxoxe ityala ungaphandle, kodwa bazawucela into yobana ke baphinde bayolungisa futhi ukuphendula la matyala ukusuka kweli tyala lesibhozo ukuya kweli leshumi kuya kweli tyala lesibhozo ukuya kwishumi elinesithandathu. Uthi kuba kufuneke baphendule ke apho bafake ke enye i-affidavit elungiselele ukuphendula kuwo loo matyala. For business worship.
Is the state amenable to the proceedings continuing with the reservation that will supplement in respect of counts 8 to 15?
The state does not have an objection, Your Worship. We can proceed.
Thank you, Your Worship. Your Worship, in support of the bail application, we have prepared an affidavit in terms of section 6011A, which I beg leave to read into the record if so permitted.
We have a copy.
Yes, Your Worship. If I'm allowed, I've given the state a copy, and I also had prepared a bundle for the court.
Oh, thank you.
May I hand it up?
Yes.
Thank you, Your Worship.
Thank you. You may proceed.
Thank you, Your Worship. As the court pleases. In the Regional Court for the Regional Division of Council held at Brakpan, case number A203 of 2026, in the matter between Matipandile Sotheni and the state, applicants notice in terms of section 6011A, I, the undersigned Sotheni Matipandile, do hereby declare under oath as follows. I am an adult male and South African citizen with the identity number 840303561889. At the time of my arrest, I was residing at Unit 10, Beverly Hills, 6 Beverly Avenue, Basomia, Johannesburg South. I am the applicant in this application in which I seek relief from this honorable court to be released on bail. I respectfully submit, as I will demonstrate herein, that the interest of justice in light of the peculiar facts herein warrant that I should not be deprived of my liberty and I should be released on bail, including the presence of exceptional circumstances. I make this affidavit of my free will and have not in any way been unduly influenced to depose thereto. The facts set out in this affidavit are true and correct, unless the contrary appears from the context. They are also within my personal knowledge. The charges proffered against me fall under Schedule 6. Thus, the purpose of this affidavit is to provide the Honorable Court with my personal circumstances and to address the factors to be considered by the Honorable Court as contained in Section 64(9) of the Act. I have been advised and understand that I bear the burden to prove that the interest of justice permit my release on bail, and I am obligated to initiate this application. The charges proffered against me are that of conspiracy to commit murder. The second charge is that of murder. The third charge is that of attempted murder. 3 attempted murder charges. Your Worship, may I be permitted? I see that there is no paragraph 4.5 and 4.6 which deals with the first one is a possession of a firearm, an AK-47, that will be count 6. The second one is that of ammunition, which will be that of an R1, R5, and a 9mm parabellum. May they then be incorporated as paragraph 4.5, 4.6F, and 4.7. I apologize for the oversight.
Any objection?
No objection, Your Worship.
As the court pleases, thank you, Your Worship. My personal circumstances. The property at which I reside is a rental property. I have been residing at the above-mentioned property since April of 2025. I had entered into a lease agreement renewable annually. A copy of the lease agreement is here to attach marked Annexure A. I am married with 2 minor children, namely Lilita Sotheni, who is currently attending grade 7 in the jurisdiction of Gauteng. I also have a minor male boy, Luteni Sotheni, currently attending grade 8. I'll move for an amendment, Your Worship. It should read as grade 8 at a high school in the jurisdiction of Gauteng. Copies of the school statements are here to attach marked Annexure B1 and B2 respectively. I own land at Block F, Pumulong Silman, Hammanskraal. A copy of the proof of residence is here to attach marked Annexure C1 and C2 respectively. I own a chicken business and the chickens situated at the property in Hammanskraal, together with Lucy Balu, the consultants, which is a consulting company. The business suffered during COVID and my subsequent loss of employment at Kalinix Pty Ltd, a cigarette company where I was employed by Mohammed. A copy of the company registration documents are here to attach marked Annexure D1 and D2. I am gainfully employed at K61 Blazer Investments since the 1st of May 2025 as a security coordinator, earning in the proximity of 50,000 rands a month. A copy of my employment letter is here to attach marked Annexure E. In terms of the provisions of Section 4A to E, I undertake that I will stand my trial should it proceed against me because I trust the South African legal system and that the facts will show that I did not kill any person. I do not know when and how I murdered the deceased. I further have no knowledge of ammunition and I was not found in possession thereof. Where there is a likelihood that the accused, if he or she is released on bail, will endanger the safety of the public or any particular person or will commit a Schedule 1 offense. There is no evidence that the state has in its possession that will demonstrate that I have a propensity to violence. I've never expressed any threat to any person. I do not have any domestic violence, harassment orders and or protection orders against me. I do not harbor any resentment against anyone. I do not have any disposition to violence, and it is evident from my past conduct. I further undertake not to commit offences referred to in Schedule 1. I will demonstrate that I have emotional, family, community, or occupational ties to the place at which I am to be tried. The assets held by myself and where such assets are situated. I'll also move for an amendment, Your Worship. On accused to read myself. I do not own assets outside of the Republic of South Africa. I do not have any relatives outside of the Republic of South Africa. I am aware of the charges proffered against me and I am informed of the punishment that may be imposed in the event that I'm found guilty. I undertake to stand trial until the matter is finalized. I am well known given the media attention that this case has received. I do not possess the incentive to attempt to evade trial. I am not familiar with the identity of witnesses and with the evidence which they may bring against me. I am not privy as to whether the witnesses have already made statements and agreed to testify. I am not aware whether the investigation against me has already been completed. I do not have a relationship with the various witnesses, and there is no extent to which they could be influenced or intimidated. The court may impose effective and enforceable bail conditions prohibiting communication between myself and the witnesses. I further do not have access to evidentiary material which is to be presented at my trial. I therefore cannot destroy or conceal evidentiary evidence that will be used in the trial. At the time of my arrest, I spoke to the members of SAPS during the interview. I never supplied false information. In the event that I'm admitted to bail, my release will not induce a sense of shock or outrage in the community where the offense was committed. I do not foresee any public disorder in the event that I am admitted to bail. My safety will not jeopardize my release. The sense of peace and security amongst members of the public will not be undermined or jeopardized by my release. I submit that my release on bail will not undermine or jeopardize the public confidence in the criminal justice system. I was arrested on the 14th of March 2026 and have been in custody since. The investigations are still ongoing and may take a while until they are finalized. The probable period of detention until the disposal or conclusion of the trial will be lengthy, and it will be prejudicial to me if I remain in custody. I will lose my employment, and this will render me in a position where I will not be able to pay for legal representation. I do not know how many witnesses the state intends to call to adduce evidence. I'm also informed by my legal representative that the matter stands to be transferred to the High Court. I anticipate a delay in the obtaining of the trial date as there are matters are given lengthier periods of postponement. The matter may be disposed of after a while. I have 2 minor children who are school going. They rely on me financially as things stand. Their fees are overdue. I was in the process of resuscitating my chicken business and all the efforts and attempts will have come to a halt. My estate will be depleted and I will not be able to keep my social fabric intact. The joint responsibilities towards my children will not be achieved. Your Worship, I have moved to delete the last sentence in that paragraph, which starts reading as any financial loss to detention.
Thank you.
I do not have any previous convictions. I also do not have any outstanding warrants, protection orders, harassment orders, neither do I have any pending cases. I am willing to comply with such conditions as the above Honorable Court may wish to impose, including but not limited to days at which to report to my nearest police station, and any condition as the court deems fit. I am able to pay bail in the amount of 30,000 rands because I do not earn any money and I rely on my family and relatives to pay for legal fees. Further, since my detention, I have not been deriving an income. On exceptional circumstances, I joined the police in the year of 2005 on the 19th of September, and I was posted at Queenstown SAPS. After completing my training in 2008, I developed an interest to SABC, and my application was successful, whereby I commenced training and finished my training in 2010 on the 19th of December. I was then transferred to the Pretoria unit. An indulgence, Your Worship. I was in the special task force until I resigned. It should read as resigned in 2019 on the 31st of August. I commenced my duties on the private sector on the 2nd of September 2019. My duties were Executive Protection Manager for Branded World, and I was assigned to close protection to the Said family at number 16 Avenue, Houghton. On the 9th of October 2024, I was dismissed from work due to other unexplained reasons, and I was staying at number 21A First Avenue, Houghton, in the property that was rented by my principal, Mr. Said. After my dismissal, I was told to move out, and I did. During the time where I was working with Mr. Said family, I met Viandre Pretorius in Etwatwa, where he had arrested a truck full of illicit cigarettes. Myself and Viandre exchanged numbers, and the interaction happened around between 2019 and 2022. Viandre would time to time comment on my WhatsApp statuses and sometimes communicate with me telephonically. I would put statuses while I was at the shooting range, and he would ask me to train him to be a sharpshooter, and he regarded me as his role model when it comes to shooting. Around November 2025, I was informed that Viandre Pretorius had been mentioned on the Madlanga Commission, and that his name had been trending on national TV as stated by the person identified as Witness D. I then checked my TV, and indeed I heard Viandre's name being discussed. I was shocked, and I contacted Viandre to ask what's going on. During our telephonic conversation, Viandre did not give full details of what transpired and requested to meet with me. I told Viandre that I'm staying at the Glen and we would meet at the Glen Mall. After a few days, myself and Viandre met at the Glen Mall parking next to the banking sector, where he came driving a white Isuzu buggy. I did not take down the registration number. Viandre started to relate a story to me that in 2022, there was an operation where he was with SAPS members, EMPD officials and private security personnel on that particular operation. There was a male person who died and later dumped into a dam. Viandre further informed me that the body of that person was transported from the scene to the dam in a buggy. He also mentioned that EMPD Police Captain Brigadier Mkwanazi was also at the crime scene where the male person did later get dumped into the dam. I could see that Viandre was in a lot of stress and seemed to be frustrated by his name trending for wrong reasons. I think Viandre looked up to me and he respected me a lot, hence he confided in me. Viandre also wanted me to take him to the shooting range for training, but it never happened. After the meeting, we went our separate ways. Few days after the meeting, Viandre called me to come to Carnival City, and we met at the filling station next to Carnival City. I vividly remember this day as it was the 28th of November. It should read 2025, not 2005 motion. This is the day that I also purchased ammunition at Dave Share Guns in Bramley, where I normally purchase my ammunition for shooting range practice. I was driving a black Suzuki Swift with registration number MP36FSGP, which belongs to my girlfriend known as Ntombizoto Bang, who I currently stay with at number 06 Beverly Hills, Unit 10, Basonia. At the Carnival City meeting, Viandre was continuing explaining his frustrations. He also showed me pictures of a Zamazama guy who was buried alive, allegedly by Marius van der Merwe. I have picked up that there was serious animosity between Viandre and Marius. Viandre even told me that he has assaulted Marius as they were no longer in a good relationship. From Carnival City, we followed each other to Brakpan area. Viandre was driving a black Swift, registration number MP36FSGP. When we got to Brakpan, Viandre stopped at a car wash, left his vehicle, and then jumped into my vehicle. Your Worship, if I may. The sentence which I read into the record that says that Viandre was driving a black Suzuki Swift with registration MP. It's supposed to read, I was driving. Because subsequently he drove in his buggy. So that we do not mess up the record. Thank you, Worship. Viandre stopped at a car wash, left his vehicle there, and jumped into my vehicle and we drove around. Viandre was the one who was driving in my Suzuki Swift and I was seated on the passenger. We drove around while talking about all his stories, asking me if I knew anyone who could help him with his problem. Viandre never specified the kinds of help that he needed, but I could tell that he wanted Marius van der Merwe killed. After driving around, we went back to the car wash and he jumped into his buggy. I also drove back to Basonia. Viandre phoned me again on the 2nd of September 2025 and requested me to come to Brakpan as he was under serious stress. Viandre sent me a location and I followed the location to a residential place and he came on foot. He jumped into my Suzuki Swift driver's seat and I sat on the passenger seat. Viandre and myself drove around the area while talking, and the main thing that he did not want to discuss his issues on the phone, but he preferred face-to-face talking. Hence, he always wanted me to drive to him, and that on that particular day, it was during the evening. After driving around, Viandre dropped himself at the location where I picked him up. I then drove home. On the fourth time, which will be the 5th of December 2025, Viandra phoned me to meet him at Brakpan area, and I proceeded still driving in a black Suzuki Swift with registration MP36FSGP. Viandra arrived in a white Isuzu buggy where he was dropped off, and the female person that I assumed to be his wife drove that white Isuzu buggy away, and I remained with Viandra. As usual, Viandra drove my Suzuki Swift and I sat on the passenger seat. We drove around the area and went to buy food at a roadhouse along the main road. I remember fueling up my vehicle at a garage next to the roadhouse, situated on the same street, and I paid with my bank card from Capitec. We stopped on the road to eat. While talking, I do not know the name of the station as he was driving. We stopped on the road to eat, and while talking from there, Viandra told me to drop him off at the police station. I do not know the name of the police station as he was the one who was driving. At no stage did I ever let Viandra drive my vehicle alone. At all material times we were together until I dropped him at the police station. Myself and Viandra waited at the police station parking lot until he phones the wife to come and pick him up, and the wife came driving the same white Isuzu buggy that had earlier dropped him. I then took my black Suzuki Swift and went home. Was that witness D had been shot and killed. I took pictures on the TV and started to send to different people, and also received some from other people that I knew. That I knew Viandre. That was the last time I went to Brakpan. I tried to phone Viandre after having learned of the killing of witness D, but I couldn't get a hold of him. After some time, Viandre phones me saying that he has confiscated his firearms. Viandre also sent me a lot of voice notes saying that he was shot but he survived. Later on, I received news that Viandre had shot himself and also saw it on TV news. Viandre's wife sent me a WhatsApp message using Viandre's cell phone to inform me that he killed himself. I know nothing about the death of witness D. I'm also informed that after the killing of witness D, it was mentioned that footage on the day of the alleged offense shows a white Chevrolet utility buggy that was seen, and that was the car that was involved in the shooting. The buggy was also said to have been found, recovered at or near London Road in the area of Alexander. That buggy was abandoned and the occupants were unknown. I do not know who that buggy belongs to. This happened prior to the arrest of Viandre Pretorius and him killing himself. There were 2 attempts to unalive witness D as he was investigating illegal mining around the Springs area. Witness D, in his testimony at the Madlanga Commission, implicated officers from Ekurhuleni SABC, and I'm not employed there, neither do I have any interest there. I left SABC a long time ago, and I've already informed the court. I did not know witness D and had no gripe with him. Viandre is the one who was mentioned as part of the officers who went on the day, as one of the officers on the day he testified about Madlanga. I'm a trained former SABC member and worked at the Special Ops. It would be unwise for me to leave my registration plates if my intention was to commit an illegal act. There was never any point of my car appearing in any CCTV footage. If the Chevrolet appeared, mine would also appear. There's no record from the gun shop register that suggested that I bought AK-47 rounds. The first responder to the scene, a paramedic, Marius, made the first call upon arrival at the scene to secure tech security at 8:49. And at that time, my car had long left Brakpan. A copy of the gun shop register is here to attach, is marked Annexure I, and a copy of the tracking report is here to attach, marked Annexure 8. I do not have nor own an AK-47 rifle. The only AK-47 rifle I carried belonged to Mr. Mohammed Said, whose employment I left on the 9th of October 2024 after our working relationship broke down due to an incident that happened in Cape Town. After the termination of my employment, I've never had any access to where the AK-47 rifle was kept. I was arrested approximately 3 months after the alleged offense, and to date, I do not know how I am connected to the offense in question. The police did not find the firearm that was allegedly used in the commission of the offense. When they took me to my residence, they found a handgun, in quotation marks a Glock, and my sniper rifle behind the curtain. I am the lawful possessor and I have competency to possess both. Copies of the competency certificate are here to attach marked as annexures F1 and F2 respectively. I have been in Brakpan 3 times, and at all times I went to meet up with Leandro Pretoria. I do not know the area well and cannot tell the court where we went. Your Worship, may I take an instruction on paragraph 10.10? May I approach? Thank you for the indulgence, Your Worship. On paragraph 10.10, on the day of the alleged offense, I was in the company of Pretorius. I left Brakpan at 20:32. We went to the police station where his wife came to pick him up in a white buggy. Your Worship, may the record delete paragraph 10.12 of that affidavit. Paragraph 10.13. I wish to emphasize that based on the submissions herein mentioned, the state's case against me is weak, and based on the evidence I have seen, the state will not be able to prove beyond a reasonable doubt that I be convicted of the offences as contained in the charge sheet and respective discharge. In conclusion, the collective effect of my personal circumstances, the extremely weak case against me, continually suffered while under detention. I am going to delete the next line again, Your Worship. Suffices as exceptional circumstances, I request that I be released on bail.
You will delete you starting with that I be released on bail.
Yes, Your Worship, and I'm deleting those provisions, hence I'm not reading them into the record. Your Worship, that will be the affidavit.
Okay, I do not have the 10.6 is not complete.
If the court looks, there was a spacing in the affidavit. I also saw that if the court pages further, it will find it will find 10.13.
Where do I find it?
It ought to have come. We deleted 10.12. It ought to have come.
But 10.12 that I have is reads exactly like the 10.13 that you read into the record, that I wish to emphasize that based on the submissions herein mentioned, the state case against me is weak, and based on the evidence I have seen, the state will not be able to prove beyond reasonable doubt that I be convicted of the offences as contained in the charge sheet and respective annexures. That is written 10.12 on the affidavit.
Then that stands to be correct, Your Worship.
So there is no 10.8.
There's no 10.13.
And then your 10.6 on the affidavit is not complete. If you can read it again so that I can note it. It says, I do not have nor own AK-47 rifle. The only AK-47 rifle I carry belonged to Mr. It stopped at Mr.
Mine reads further to say that it belonged to Mr. Mohammed Said, whose employment I left on the 9th of August 2024.
Just hold on. We continue.
After our working relationship broke down due to an incident that happened in Cape Town. That should be the end of that paragraph, Your Worship.
Thank you.
Your Worship, the affidavit before court has been signed by the applicant. It has further been commissioned by the Commissioner of Oaths. And if the court so allows, I believe that it be accepted as an exhibit.
Mr. Sotheni, do you confirm the content of this affidavit as read out by your defense counsel? You also confirm that you do not have any pending cases or any previous convictions?
That's correct.
Thank you. That is the exhibit A.
As the court pleases.
Is that
No,
your...
That won't be my case. However, Your Worship, we are requesting just for a short adjournment that the applicant would like to relieve himself.
10 minutes? 5 minutes?
5 minutes will suffice, Your Worship.
Okay, then we will resume again at 25 to 1.
As the court pleases.
That's what I also believe myself.
Act 108 of 1996. I perform my duties in terms of Section 13 of the South African Police Service Act 68 of 1995, right with Section 205 of the Constitution of the Republic of South Africa, Act 105 or 108 of 1996. I am the investigating officer in this matter. I have been mandated to investigate offences falling within the mandate of the Organised Crime and Commercial Crime. These include the financial investigation, which addresses the offences relating to fraud, Section 4, Section 5, and Section 6 of the Prevention of Organised Crime Act 121 of 1998, referrals by the Financial Intelligence Center as stipulated in Section 40 of the Financial Intelligence Center Act 38 of 2001, and offences referred to in the Prevention of Constitutional Democracy Against Terrorism and Related Activities Act 33 of 2004, as well as the Madlanga Commission governed by the Commissions Act 8 of 1947 recommendations. The facts contained in this affidavit are true to the best of my knowledge and belief. I am aware that I make myself liable to prosecution whereby I willfully state anything herein that I know to be false or do not believe to be true. This affidavit is made in opposition of the applicant's application for bail. Oh, fine. The docket in this matter, this Brakpan case 75 of 12 to 2025, was assigned to the National Task Team investigating the recommendation of the Madlanga Commission on 10 February 2026. Marius van der Merwe, the deceased, testified as witness D at the Madlanga Commission regarding the operations in Brakpan on the 14th of April 2022, during which the SABC members, the EMPD members, and private security personnel were implicated by the deceased in an unlawful death of a suspect, Emmanuel Mpenze. The suspect died during the interrogation, and his body was transported from Brakpan to Spar Waters Dam near Nigel area in an attempt to conceal their criminal conduct. Mpenze's body was subsequently discovered by a fisherman, and the case was registered as per Brakpan case 429 of 4/2022. This case is currently under investigation by the Independent Police Investigating Directorate, that is the IPED. Among the suspects in the Brakpan matter was Willem Vienre Pretorius, who reportedly committed suicide on the 7th of February 2026. I'm now on paragraph 8, that is the status of the deceased. The deceased testified before the Madlanga Commission of Inquiry into Criminality and Political Interference in the Criminal Justice System on the 15th of November 2025. His testimony relates to a 2022 incident in Silas Village, Brakpan, involving a warehouse robbery investigation and alleged misconduct by the law enforcement officials as discussed in paragraph 7 above. The deceased was going to give evidence in a criminal trial in a Brakpan matter dam that is now referred to as Mpenze matter. The deceased had already given a statement under oath and was filed in the docket. The circumstances of the offense. On the 5th of December 2025 at approximately 20:32, the deceased Marius van der Merwe arrived at his residence at Hout Street, Brandhurst, Brakpan, with his wife and 2 minor children. While the family was in the driveway preparing to enter their place of residence, a dark-colored hatchback motor vehicle approached slowly. The deceased exited his vehicle while holding his licensed firearm in order to open the gate. The hatchback vehicle accelerated towards the driveway and stopped nearby. A passenger inside the hatchback vehicle fired 2 shots through the window towards the direction of the deceased. The deceased was struck by one of the shots and collapsed next to his vehicle. The suspects fled the scene. Emergency medical personnel declared the deceased dead at the scene. Paragraph 17, the evidence against the accused. During the investigation, it was established that prior to the murder, the deceased had, in a WhatsApp group, informed his friends that he had been followed by a black Suzuki Swift motor vehicle registration bearing registration number MP36FSGP. During the investigation, it was established that prior to the murder, the deceased had in a WhatsApp group informed his friends that he had been followed by a black Suzuki Swift motor vehicle bearing registration number MP36FSGP. The message that he sent to his friend reads as follows. Now, quote, open quote, MP36FSGP found the car around my house last night and this morning numerous times. Three dots that were on the message, and then he writes 3 occupants, close quote. This message was sent on the 3rd of December 2025. The deceased further informed his friends that he had previously observed a similar vehicle near his residence, approached it in order to confront its occupant, whereupon the vehicle sped off. The INATIS records confirm that this vehicle is registered in the name of Ntombi Zodwa Bango, who in turn confirmed that this vehicle is frequently driven by her boyfriend Matipandile Sotheni, the applicant. The tracker, forgot. My apologies, Your Worship. We did discuss with the interpreter, Mr. Mvanda, but that I'm gonna take it step by step for him to interpret, and then I just got carried away. I apologize.
Sifunda ke i-affidavit elungisiweyo ke okanye ingxelo efundelweyo lipolisa ke eliphanda ityala eli elinguLawrence Sibonelo Siyanda Mandlalose atsho ke ke athi ungumuntu oyindoda osebenza ke icandelo lesipolisa uchazile ipesana yakhe apha uyatsho into yobana ke usebenzela i-National Trust Team uyaphanda khona ke uthi ke wayethunyelwe nayiMadlanga Commission ukuthi enze kanjalo ukuthi aphande echaza imisebenzi ayenzayo nendlela afikelele kuyo emfandeni lakhe futhi ke esitsho ke esithi ke uyazi into yobana ke kufuneke ethethe inyani azise into enobunyani ngoba angazibona esengxakini yokuthuthiswa makungenzeka into yoba azise into engeyonyani phambi kwalenkundla futhi ke uyilungisile ke yena ke le affidavit elungiselela le mini yanamhlanje uyatsho ke ukuthi dokethi ke lilapha ke eBrakpan le case number ke 75 12 2025 futhi ke elo dokethi ke wanikezwa ke kwi-investigation team ke nge-10 kaFebruary 2026. Uyatsho ke ukuba uMarius oswelekileyo yayinguye ke umuntu owayenikeza ubungqina elingqina lesine kuleya commissioner ke kaMadlanga. Futhi ke uthi nge-14 zika-April 2022 bebephanda ke into eyenzekayo ebandakanye ke amalungu wasesipoliseni kwakunye ke nabonogada babucala into abathi bayenza engalunganga ngexesha ababezama ukufumana ke umrhanelwa ongu-Emmanuel Mdembe lowo ke bathi bambulala ngexesha bazama ukufumana inkcukacha kuye baze bathatha ke umzimba wakhe bawususa eBrakpan bewusa ke kwidama ekuthiwa yi-Swarwater Dam engaseNiger bezama ke ukufihla umzimba wakhe nobungqina ke kuthiwa ke uMdenge waye wafumaneka ke efunyanwa ngumlobi wenkanzi kuthi kwavulwa icala ke eBrakpan icala elokuthiwa nguCas 42904 of 2022 libizwa ke ecala njengomdlenge ecala futhi ke liphandwa ngamapolisa abucala aphanda izenzo zobugwenxa ezenziwe ngamanye amapolisa uthi ke kwabanye ke kwabarhanelwa ababekhona kwelo cala lokubulawa kwakhe inguVelem Pretorius ongasekhoyo owaye ke wachaza ukuba wazithatha umphefumulo wakhe ngomhla we-7 kaFebruary 2026 uthi ke sichaza imeko kaMfi njengoba ke kuthiwa ke uMfi lona ke waye ke wabane ukuthi ke anikeze ubungqina kwikomishina ke kaMadlanga nge-15 kaNovemba 2025 futhi ke echaza ngesehlo esehlayo ngonyaka ka-2022 in Service Village ebandakanya ke i-warehouse okanye indawo egcina izinto apho kwakurojwe khona ke okanye kwaphangwa khona abantu, nokuthi ke umthetho okanye ke abantu abasebenzela umthetho, amapolisa kwakunye namanye amagosa omthetho enza izenzo ezibugwenxa njengoba besesichazile ke kulaa mqolo wesixhenxe. Kuthiwa ke benikeza ke ubufakazi ke apha ke kule ndawo yaseBrakpan malunga neMbhenge meda ukubulawa kukaMbhenge. Kuthi ke lo otshonileyo ke ngoku besenikezile imbalelwano ebhaliweyo nefungelweyo wayifaka kwidokethi lelityala. Kuthiwa ke ngoku imeko okanye indlela yokusweleka kwakhe kuthiwa ngomhla wesi-5 kuDisemba 2025 ngexesha lapha ngecala emveni kwentsimbi ye-20 emva kwemini. Kuthiwa ke uMarius van der Merwe lo afika ke kwindlu yakhe ahlala kuyo eArt Street branches apha eBrakpan, ehamba ke nonkosikazi wakhe kwakunye nabantwana bakhe ababini abancinci. Kuthiwa ke ngeli xesha ke bafikela kule ndlela ke ingenayo apha izawungena ke eyadini. Kuthiwa ke emveni koko yena waphuma apha wabona ke imoto enombala ongathi awubonakali futhi ke engenamva. Kuthiwa ke i-dashboard loo moto isiza ixosha. Uthi ke yena ke waphuma emotweni yakhe ebambe ke umntu wakhe lo unelayisensi ukwenzela into yobana azovula igeyithi yendlu yakhe. Uthi ke le moto yena yayeza phambili ingxamile, yafika ke yema apha kude kufutshane ke nale ndawo azawuvula kuyo. Kuthiwa ke umntu owayehleli kweli cala engaqhubi kwaye ke wakhupha umpu wadubula ke iimbumbulu ezimbini ekuyo umfi lona. Uthi ke wamchana ke ngeembumbulu, wabethwa yenye ke yembumbulu wawa phantsi waquleka okanye ke wafiskaqa ecaleni kwemoto yakhe. And then kuthiwa ke nina ke okanye ke abarhanelwa abo baye babaleka ke kuloo ndawo yexhwayelo. Kuthiwa kwabizwa ke uncedo lokuqala ukuze bazonceda, baye ke bafika bachaza into yobana umfi akasekho. Kuthiwa ngeli xesha ke kuphandwa elityala likamfi, umfi yena ukhe wathumela phambi koba abe kanti uyabhubha, ukhe wathumelela abahlobo bakhe imbalelwano kwefowuni, kuWhatsApp kutshoko, echaza into yobana kukho imoto endilandelayo eyiSuzuki emnyama, iSuzuki Swift emnyama enombhalo othi MP36FS GP. Kuthi ke wasenda ke kubahlobo bakhe chaza into yobana le ayiqali ukundilandela le moto, ihlala indilandela. Ndiyacabanga inoba amatyeli amaninzi le moto indilandela. Uthi ke loo mbalelwano wayithumela ngomhla we-3 kaDisemba ka-2025 exelela ke abahlobo bakhe into yobana le moto isoloko nje imane indilandela isiza. Ndikhe ndazama ke ukuya kule moto ndiyoqonda into yoba ingaba bafuna ntoni na, kodwa ke uthi khange ndikwazi ukufikelela kuloo moto kuba yaye yabaleka ke imoto. Futhi ke iyachaza ke into yobana imoto yona le ingubani umnikazi wayo. Umnikazi wayo nguNtombi Zodwa Bango. Kuthiwa ke waye wachaza naye ukuba imoto iye imane isetyenziswa nguwe njengeqabane lakhe uMatipandile Sotheni.
Paragraph 20, Your Worship, on page 6. The tracker data obtained through a 205 application confirmed the said Suzuki motor vehicle with the registration number MP36FSGP was present in the vicinity of the deceased resident on at least 2 occasions, that is being on the 29th of November 2025 and 2 December 2025. The state alleges that this conduct is indicative of prior planning and surveillance on the deceased before he was murdered.
chaza ke umtshutshisi ethi ke nababe betracker ke abalandela ke ukuba imoto zihamba ndawonye but ke section 205 iyachaza into yobana le moto iluhlobo lweSuzuki engu-MP36 FS GP ibikhe yafumaneka ngakwindawo yefayelo apho kutshone khona ke umfi iintsuku ezimbini kuthiwa ke ngomhla we-29 zikaNovemba yayiboniwe le moto nangomhla wesibini kaDisemba yayikhe yabonakala le moto futhi ke uyeza ke umtshutshisi echaza into yobana iyacaca into yobana le nto yenzekileyo yindlela ebekuhlelwa ngayo phambi kokuba ke abe kanti umfi uyabonakala.
Call data analysis reveals suspicious behavior on the part of both Pretorius and the applicant, that their cell phones were switched off while traveling to Brakpan in the same vehicle. This conduct is also indicative of a deliberate attempt to evade detection. The applicant, in his warning statement, admits to having traveled to Brakpan in the same vehicle as Pretorius.
Iyatsho ke into yobana ke kwela candelo lokucalulwa kweminxeba apho ke bajonga khona izinto ezenzekayo bathi kuyabona khona ukungaqondakali kwendlela yokuziphatha ngoba ngeli xesha uPretorius kwakunye naye nawe ke wena ucela isicelo sokuxoxa ngaphandle kubonakala into yobana iminxeba yenu licinyiwe ngexesha ebenihamba kule ndawo yaseBrakpan futhi ke wena ke ukhe wachaza nawe kwimbalelwano yakho into yokubana ubukhe wahamba naye lo uchazwayo nguPretorius kwindawo yaseBrakpan.
On the 5th, that's paragraph 22, Your Worship, on the 5th of December 2025, being on the day of the murder, the tracker data shows the same vehicle traveling towards Goud Street, that is where the deceased lived, and shortly before the shooting. The applicant, in his warning statement, admits being in the vicinity of the deceased's place of residence with Pretorius on the day of the shooting.
Iyachaza ke futhi ukuthi iyabonisa ukuba ngo-25 zikaDisemba ngosuku apho kubulewe khona iyabonakalisa ke i-tracker into yobana ke bekukhe bahanjwa ngale moto kusiwa ngakwindawo ekuthiwa yiGold Street apho ke khona umfi ahlala khona nalapho emveni koko kafutshane nje kwaye wabulawelwa khona futhi ke nawe ukhe wavuma phambi kwenkundla into yobana bukhe wahamba ngeli xesha lichazwayo enkundleni yomtshutshisi.
The applicant was issued with a 7.62 by 39mm caliber Nerocom model semi-automatic rifle with the serial number S47170-135 by his employer in the execution of his duties. This firearm was subjected to ballistic examination. Among other factors, it was found that the ejector of the rifle was grinded off and or filed off and or tampered with, and the bolt carrier and bolt from another firearm with the serial number S471703074717004 of the same caliber firearm was fitted in the applicant's firearm.
Yachaza ke futhi into yobana ke kwawo wanikezwa ke umntu oyi-7.62 39mm caliber ukuthi ke kuyabonakala ke apha ngexesha kuthathwayo kuyohlolwa ke uhlolo lwezibhamu kuye kwafumaniseka into yobana kuthe kwakho ke kuphazamiseka kwindlela owakhiwe ngayo umphungo kwakho izinto ezikhutshiweyo nezinto ezingathi zikhuhliwe kwaphindwa kubonakala ngathi kufakwe ezinye zomnye ngoba ke umtshutshisi efunda ethe sifumanekileyo ke S4717004 ubonakala into yobana ke ufakwe kwakuwo lo mpu usebenzisana.
According to the ballistic experts, the bolt carrier and the bolt are referred to as critical parts of a firearm as they leave unique marks that can be traced to a specific firearm. Notwithstanding,
ke ingxelo ke echaziweyo ke ngokuzibhamu iyathi into yobana ke ezi zinto zimbini le bolt bolt carrier kwakunye nebolt le zezona nto zibalulekileyo apha kumntu ngoba zizo izinto ezingathi umntu xa usetyenzisiwe ukwazi ukujongwa ukuba ingaba ngumntu osetyenziswe ngubani esetyenziswa xeshana.
Notwithstanding this tampering, ballistic analysis confirmed that the cartridge cases recovered at the scene of the murder were fired from the firearm issued to the applicant.
uthi-ke nangona kunjalo kuyabonakala-ke ngokuphando into yobana-ke imbumbulu okanye-ke amakhatriji la afumanekileyo kwindawo yexhwayelo ayabonakala uba ayisetyenziswe ngumntu lo ubunikwe wona.
This conduct shows a deliberate interference with the firearms identified and forensic features consistent with an attempt to conceal its use in the commission of the offence and to evade ballistic detection.
Uthi-ke okuphazanyiswa-ke kwezinto ebezifakwe kulo mphunga ngendlela owakhiwe ngayo yiyo-ke indlela yokubalekela uphando oluzawuthi lwenziwe emveni kokuba-ke umntu usebenzile ukwenzela into yobana aba baphandayo ukusetyenziswa kwemipu bangaboni into yoba umntu usetyenziswe ngubani njani.
The company's firearms register indicates that the firearm with the serial number S47170004 was in the possession of another employee of the tactical service security services, that is the applicant's employer, and who was stationed in a different site.
Uthi-ke kuyabonakala into yoba umpu lo osetyenzisiweyo okanye-ke ubhaliwe okanye lobhaliweyo uyabonakala into yobana yena-ke le serial number S47170004 wawukuye komnye umsebenzi osebenzela-ke i-task security service uthi-ke umqashi kuwe lowo owayekwenye indawo ngelo xesha.
Upon arrest, the following ammunition was found in the applicant's place of residence, where he lives with his girlfriend at Unit 10 Beverly Hills in Persona in Johannesburg.
Uthi ezi zinto-ke emveni koba-ke ube kanti okanye-ke phambi koba-ke ubanjwe okanye ngexesha obanjwa ngalo ke izinto ezaye zafumaneka endaweni ohlala kuyo neqabane lakho Unit 10 Beverly Hills Bosnia eJohannesburg.
In the kitchen, in a black plastic bag containing different types of ammunition was found. It is worth mentioning that this ammunition was state-issued ammunition, which is unique to the police and identifiable by a letter P stamped at the back of each ammunition.
Uyachaza-ke uthi-ke emveni koba bafikile-ke ekitchen okanye kwindawo-ke yokuphekela kwafikwa-ke kwibhegi emnyama igcwele-ke inhlobo-ntlobo zembumbulu ezahlukileyo futhi-ke kuye kubalulekile into yoba siyichaze apha kule nkundla into yobana-ke ezo mbumbulu zafumanekayo ziimbumbulu ezithi zisetyenziswe ngamapolisa ngoba ziye zinophawu olungu-P olubonakalisayo olubethwe apha ngasemva.
The following state-issued ammunition were found: 125 rounds of a 6.56 by 45 millimeter ammunition, 31 rounds of 7.62 by 51 millimeter ammunition, 17 rounds of 9 by 19 millimeter ammunition.
Ezi zinto ezimbumbulu ezafumanekayo-ke imbumbulu ezilikhulu ezinama-25 ezohlobo lwe-5.56 45 millimeter ammunition kwakunye-ke nezi-31 imbumbulu eze-7.62 by 51 ammunition kwakunye-ke nezinye eziyi-17 eze-9 millimeter 19 millimeter ammunition.
At the lounge behind the sofa, a licensed .308 caliber rifle semi-automatic firearm was found with 4 live rounds loaded in a magazine.
Uthi-ke emveni kwesofa kwaye kwafumaneka-ke umntu osemthethweni oyi-308 caliber rifle semi-automatic rifle ke umshini otshintshayo wafunyanwa-ke uneembumbulu ezine ezifakwe kuwo kwimagazini.
In a passage cupboard inside a Woolworths bag, the following was found: 3 90mm magazines, 2 of them were empty, 1 was loaded with 12 rounds of ammunition, 1 loaded magazine with 12 rounds of ammunition, and 14 empty cartridges of a rifle.
Ezinye izinto ezafumanekayo-ke kwipassage ebhokisini kwibhegi ke yabawoolworths lezi zinto zilandelayo 3x9 magazini ezimbini ke bezingenanto okanye zi-empty eyodwa ke yayifakwe ke imbumbulu ezilishumi futhi ke enye imagazini yafumaneka nayo inembumbulu ezilishumi futhi ke enye ezi-14 zafumaneka ke zingenanto ama-cartridge wama-rifle ayi-14.
In the main bedroom, the following was found: a spent rifle cartridge, 1 box of ammunition of a .308 Winchester, and 1 box written simulation mag containing 2 9mm extended magazines, each containing 7 rounds of ammunition, and 38 empty cartridges of a rifle.
Wafumaneka ke amayinite i-cartridge ye-rifle kwakunye nebhokisi eyodwa ye-ammunition ke okanye ke imbumbulu of i-308 Winchester, and ke nenye ibhokisi ebhaliweyo mag containing i-9mm ezimbini, imagazini ezimbini ze-9mm, kwakunye ke nembumbulu ezine ezisixhenxe, kwakunye ke ne-38 ama-cartridge ke oye-rifle angenanto.
In a wardrobe of the second bedroom, a special task force full uniform consisting of a jersey, a name tag with his name, a rank insignia of a warrant officer, a pair of trousers, a shirt, a pair of shorts, and a beret were found.
kwakunye nento echazayo ukubana ke undawona apha esipoliseni ibhaliwe warrant officer kunye nebhulukhwe ezikhoyo kwakunye nezikipa kwakunye nebhulukhwe ezifutshane kwakunye neberet into entloko zizinto zazifumanekile.
Paragraph 27, Your Worship, that is in opposition of bail. This statement is submitted for the purpose of opposing the applicant's bail application. A 42-year-old male with identity number 840303561808 now. The applicant was arrested on the 14th of March 2026.
Today, apha ke ekuphikiseni ke kwesicelo sebeyile yatsho ke into yokubana ke walapha ke okanye ke indoda eminyaka emi-42 ene-ID number echaziweyo onguye ke esinesicelo ocela ukuthi athoxe icala ngaphandle waye wabanjwa ngomhla we-14 zikaMarch 2026.
The applicant is before court for committing an offence that falls within the ambit inter alia of Schedule 6 of the Criminal Procedure Act 51 of 1977, right with Schedule 2, Part 1 of the Criminal Law Amendment Act 105 of 1997.
Uthike wena ke esisicelo sakho ke sokuxoxela ungaphandle siwela ke lamqondo wesiqondathu phansi ke kwemithetho ebhaliweyo yesibeleni ka-51 of 1997 utsho ke uthi ke yona ke umthetho lowo owaye waphinda walungiswa ke ila Act ka-105 of 1997.
Your Worship, I see that the time now it's 1:05. I was informed by the court personnel that the court does take lunch at 1. We were just asking, with the indulgence of the court, if the state can be allowed to finish its application for bail, or rather reading the affidavit on record, and then we can take lunch afterwards.
Can we proceed?
Thank you, Your Worship. We're now on paragraph 29, page 9. The applicant is charged with murder wherein the murder was premeditated and the deceased was likely to give material evidence in a criminal proceeding and has already testified before a Madlanga Commission, which was established under the Commissions Act 8 of 1947, wherein the deceased implicated other persons. Furthermore, the murder was committed by a person, a group of persons acting execution or furtherance of a common purpose or conspiracy.
Uthi-ke wena ucela isicelo sakho ke ubekwa ityala lokubulala yaye bekubulala umuntu ezamnika ubungqina ubungqina obo ke ezakunika bubalulekileyo kwinkundla kamadlanga apho ke ebesebenikezile obunye ubungqina ngaphambili futhi ke uyabona into yobana ke okubulawa kwakhe ukubulawa okuye kwahlelwa ngendlela ethile ningabantu okanye umuntu ukuze nimbulale ukwenzela into yobana ungaqhubekeki netyala.
Therefore, the applicant must show that exceptional circumstances exist in which in the interest of justice permits his release.
Uthi-ke funeka uze phambili kwenkundla ke wena ke uze neenkcukacha nobungqina okanye ke into evakalayo eza kubangela into yobana ukulungiswa komthetho bukulungela uba kusoketyala ngaphandle.
I now deal with the grounds set out in section 460, subsection 4 of the Criminal Procedure Act 51 of 1977 here under. The applicant rents a flat at Unit 10 Beverly Hills in Bosonia, Johannesburg, that he shares with his girlfriend Dombizodwa Bango and a minor child. He also has a wife and 2 minor children that reside at Bedford View.
Uthi-ke ngoku-ke ndizawubeka ke izinto ezisapha enkundleni ezichazayo into yobana ke lo ucela isicelo sebheyili uyachaza into yobana ke kunendawo aqhwakhe kuyo e-Unit 10 Beverly Hills in Bosonia eJohannesburg. Ke leyo ndawo uhlala kwakunye neqabane lakhe kwakunye nomntana omncinci iqabanekazi lakhe elinguNtombizodwa Bango. Unaye ke nenkosikazi nabantwana ababini abahlala eBedford View.
This demonstrates that he has access to multiple residents.
Kubonakalisa ke into yobana unamakhaya amaninzi.
Both partners, that is the wife and the girlfriend of the applicant, are gainfully employed. The wife is employed by Passenger Rail Agents of South Africa, that is PRASA, and the girlfriend is employed by a retail shop at Hyde Park in Johannesburg.
Uthi-ke obabini ke lamaqabane wakhe unkosikazi wakhe kwakunye nesibonelelo sakhe obabini bayabonakala into yobana bangabantu abasebenzayo njengoba unkosikazi wakhe esebenza e-Passenger Rail Agency of South Africa iPRASA ngamafutshane kunye ke neqabanekazi lakhe okanye nesibonelelo sakhe esisebenza kwindawo ekuthiwa yi-Hyde Park eJohannesburg.
The investigation did not find any substantial assets that the applicant owns. He has been renting a flat in Bosonia since 2024 and pays rent of 10,800 per month. The applicant's employer refused to share information relating to his salary and or remuneration.
Uthi-ke abantu abaphantsi ityala ke abakwazanga kufumana into eyiyo into yobana yintoni na eyona nto abe kanti unayo njengokuba ke engumntu oxhafileyo kule flat yaseBosnia since unyaka ka-2024 ebhatala ke imali engango-10,800 ngenyanga futhi ke nomqeshi wakho akafunanga kunikeza izinkcukacha malunga nemali okanye ke umrholo wakho nemali onazo emsebenzini.
It is therefore submitted that the applicant's family will not be detrimentally affected financially as a result of his incarceration.
Uthi-ke iye yabonakala ke achazwa enkundleni kubana ke ukubana ngaba ke wena bagcina ngaphakathi eluvalelweni angeke babe kanti bayaphazamiseka ngokwasezimalini usapho lwakho.
Your Worship, application to amend supposed to be the applicant, not the accused. Thank you. The applicant is employed as a VIP protector at Tactical Security Services since 1 September 2024 and was placed on suspension because of this arrest. Although the applicant does not possess a passport and has not traveled outside the Republic of South Africa, given the type of occupation, the high quality of training that he has received with the Special Task Force, his skills are highly sought in international security sectors, thereby increasing his ability to secure employment outside the Republic of South Africa, particularly in jurisdictions where extradition processes may be difficult and where we do not have treaties.
Futhi ke ngibona ke lo ocela ukuba axoxele ityala ngaphandle engenawo amaphepha wokuhamba okanye uma ngapha kweMzantsi Afrika, kodwa ke ngendlela esijonge ngayo, indlela aye waqeqeshwa ngayo nendlela aphethe ngayo ayingaphethe ngayo kumsebenzi awenzayo, uphethe ke iqondo eliphezulu kakhulu elingeke limhluphe xa engumuntu ongahamba ayofuna umsebenzi ngaphaya kweMzantsi Afrika, apho ke anothi angafumaneki khona, noba mhlawumbe ngathi kuzame iinzame zoba abe kanti uyafunwa angafumaneki. Futhi ke yeyona nto ebangela into yobana ke ibe kanti ingxaki uba ngabe kanti uyakhululwa.
The applicant is therefore a flight risk, given the serious nature of the charges that he is facing, as well as a strong case against him. The possibility of a substantial custodial sentence, including life imprisonment, may have a strong incentive to evade trial.
Uthi ke na ke ubonakala ngathi ngumuntu xa kujongiwe ungayibalekele ityala ngenxa yento yoba indlela eliyo okanye ukuzaza betyala ujongene nalo lilo elingakubangela uba ube kanti uyabaleka, nesigwebo ongasifumana xa unofunyaniswa ulahlwa letyala okanye unetyala, yiyo ke yona nto ingakubangela uba ube kanti uyabaleka ungafuni ukulimela ityala lakho.
Investigation reveals that the applicant is a former member of a South African police attached to a special task force, that is STF. Members of such unit receive advanced specialized training and targeted operational skills. The manner in which the offense was executed, namely a targeted drive-by shooting directed at the deceased while he was entering his place of residence, is consistent with a planned and coordinated attack carried out by a person or persons with such proficiency.
Uphando ke luyabonakalisa into yokubana wena ke ungumuntu ofumene ukuqeqeshwa kwimizandla ngokusebenzisa umkhomekati nangendlela okusetyenziswa ngayo obudumlilo nangendlela umuntu aqeqeshwa ngayo, kuthiwa ke ubonakala njengomuntu ofuna izandla njengoba ubukwela candelo le-specialized training and targeted operation skills, uthi ke leyo special task force i-STF, uthi ke leyo nto yile ibangela uba ube kanti naxa phandle wayo ngetyala kubonakala indlela le umfi abulewe ngayo nendlela le izinto ezenziwe ngayo zihlelwe ngayo, iyabonakala into yobana ke yenziwe ngumuntu onesiqiniseko sokuba uyakwazi akwenzayo.
This is confirmed by the ballistic analysis report, which reveals that, I quote, number 1, at least 2 shots were fired at the scene. Number 2, the deceased was fatally hit by 1 high velocity in bracket rifle bullets. Number 3, the second bullet missed him and hit a steel of a gate. 4, both shots were aimed at the head of the deceased. 5, the deceased was hit while in the process of alighting from the vehicle, while positioned between the open door and the driver's seat. The blood stains on the doorstep, door panel, and the bonnet placed the deceased at the said position, and the wounds sustained by the deceased were immediate, incapacitating, where he dropped immediately. Close quote.
Le nkcazelo sizisa apha enkundleni kuchazwa ngaluhlolo ke ngezibhamu, kuthiwa ke iimbumbulu ezimbini zizo ezadutyulwayo kwindawo yexhwayelo, kuthiwa ke umfi wabulawa nje imbumbulu engxamileyo eyodwa, futhi ke eyesibini imbumbulu yabetha ke intsimbi yegeyithi, uthi ke zombini ezimbumbulu zazijongiswe entloko, uthi ngeli xesha ke wayechanwa yena zezimbumbulu kuleli xesha besohlika apha emotweni, uthi ke kuyabonakala ke nakwindlela le ufikwe eyiyo amachaphaza la wegazi ayabonakala uba wayelapha ngasemnyango esandikusuka kwisitulo esi sakhe sokuqhuba, futhi ke yonke loo nto iyabonakala, futhi nenxeba eli liye lafunyanwa nguye umfi beli lambangela uba abe kanti ngoko nangoko uphulukana nobomi bakhe wabe isiwa kwixeshana.
The degree of violence displayed in the commission of this offense is exceptionally high. Shots were fired while the deceased was in the presence of his family, namely the wife and his 2 young children. The applicant and his accomplices displayed a complete disregard for the trauma inflicted upon the wife and the children, who witnessed the murder of her husband and their father.
njengokubonakala into yobana yonke le nto yenziwa phambili kwabantwana bakhe kwakunye nenkosikazi yakhe. Kuthi ke loo nto leyo abo bantwana babini kwakunye nenkosikazi yakhe ngabo ke abantu ababebonile loo nto leyo. Kuthi ke wena ke njengomntu olapha enkundleni kuyabonakala into yobana ufake ukoyika nokuphazamiseka kakhulu kwifemeli okanye kusapho ke lukamfi njengokuba eyindoda emfazini wakhe endike engutata ebantwaneni.
There is a strong likelihood that if released on bail, the applicant will attempt to evade, will attempt to influence or intimidate the witnesses. The applicant's former employer is a South African Police Service, and he maintains relationship with his former colleagues. He may easily use this connection to interfere and or tamper with evidence.
Kuyabonakala into yobana ungaphazamisana okanye woyikise amanqina kwetyala uwavuvise futhi ke wena ke umuntu okanye ke umsebenzi usebenzela uxelelela elicandelo lasesipoliseni usenabo futhi abahlobo futhi kungaba lula kuwe ukuthi usebenzise indlela ezithile zokwazi abantu ukuthi uphando oluphazamisana nalo.
The murder weapon is a AK-47 automatic assault rifle, which was found in the vehicle that was parked at the Bedford View residence. The vehicle was issued to the applicant by his employer. Now on page 12, 30.12, Your Worship, the applicant is aware of the identities of the witnesses, who are his former colleagues. They are expected to testify regarding the firearms that were tampered with and or exchanged with components of parts of other firearms. The witnesses may feel intimidated and or unsafe should the applicant be released on bail. This concern is further amplified by the nature of the offense, the targeted manner it was executed, and the manner in which the applicant tampered with these firearms. It is my submission that the applicant was able to tamper with the firearm that was issued to him by his employer. The deceased in this matter was a witness that testified in the Madlanga Commission, whose identity was protected. The murder of such a witness constitutes a direct attack on the administration of justice. Courts have repeatedly emphasized that elimination or intimidation of witnesses poses a serious threat of the rule of law and the proper functioning of the criminal justice system.
Kodwa ke nangendlela le indlela aye wahlaselwa ngayo iyabonakalisa ke futhi ibonakalisa phandle into yobana ke umthetho ingalo yomthetho yona iye yabonakala ukuba iyadeleleka futhi ke kuyacaciswa ezinkundleni zomthetho ukuba ukubulala okanye koyikisa umuntu onikeza ubungqina kutyala othile kuba yingxaki enkulu kakhulu iphazamisa uphando.
The circumstances of this matter indicate that the deceased was targeted shortly after giving evidence before the commission, which raises grave concern regarding the safety of other potential witnesses.
Kuthi-ke imeko kwetyala ziyabonakalisa into yobana umfilo uye waba kanti ungumuntu obulawayo nje emveni koba enikeze ubungqina bakhe kuleya komishini kaMadlanga. Ichazeke loo nto ivuseke ukoyika okukhulu kakhulu nakwabanye abantu abafuneke benikeze ubungqina kula matyala.
The release of the applicant may create fear among witnesses and may discourage individuals from cooperating with law enforcement authorities.
Ukukhululwa kwakho ke uxoxele njalo ngaphandle kungabangela into enkulu kakhulu kwamanye amanqina futhi abangela ukuba amanye amanqina ajibilike ayeke ngokufuna ukunikeza ubungqina ngoba azabe esekela ubomi babo.
It is also my submission that the applicant's release on bail will induce a sense of shock and outrage within the community, which could lead to the public disorder, especially in light of the allegation that he killed a witness whose identity was protected. The interests of justice do not permit his release, as there is a likelihood that the applicant, if released on bail, will jeopardize the objective or proper function of the criminal justice system, including the bail system.
Futhi-ke ukukhululwa kwakho uxoxele ngaphandle ingadala umthuko omkhulu kakhulu nengqokolo engenzeka emphakathini okanye kuluntu ngokubanzi njengokubana-ke kubonakala into yobana kwalo umuntu obenikeza ubungqina uswelekileyo igama lakhe belikhuselekile futhi-ke ingaphazamisana ngokomthetho futhi-ke ubulungiswa komthetho abuvumelani noba ungabe kanti uyaphuma wena ngebheyile ngoba kuyabonakala into yobana xa ungaphuma ngebheyile ungaphazamisana futhi-ke nokusebenza komthetho.
In a Brakpan matter, the Mpenza case, the deceased was both a witness and in the Brakpan matter case, that is the Mpenza case, the deceased was both a suspect and a witness. At least 2 other persons who were suspects were killed in a similar manner of shooting, which is consistent with the present case. These 2 matters remain under investigation and are unsolved to date. This pattern of targeted violence constitutes a further compelling reason why the applicant ought not to be released on bail.
Uthi-ke kwayena-ke umfi wetyala ebenguye umkhanelo ekwalilo nengqina kwelo tyala likambhenge futhi-ke abanye ababini nabo abantu babonakala ngathi nabo babulewe ngendlela efanayo nale ndlela kwenzeke ngayo ngoku. Itho-ke loo nto inikeze ukuba kukhona indlela ethile esetyenziswayo ngoku indlela enye esetyenziswayo ukuthi abantu babe kanti bayabulawa. Itho-ke loo nto ukuba bekufanele bangabuyi kanti bakhutshwa ngebheli.
The matter of such a witness demonstrates an attempt to silence individuals providing information regarding serious criminal conduct.
Uthi-ke ukubulawa kwamanqina ibonakalisa ngaphandle into yobana kuzanywa ukuthuliswa abantu abazisa ubungqina phakathi kwabantu abenza ubundlobongela apha kwezibunzima.
The offense appears to have been planned and calculated as evidenced by the surveillance conducted at the deceased's place of residence prior to the murder.
Uthi-ke esi senzo siyabonakala into yobana sisenzo ebesihlelwe ngendlela eyiyo bonakalisa-ke kwizinto okanye-ke iikhamera ezijongileyo ezibonisayo ezipha kulo mzi kamfi ezibonakalisa phambi kwakhe kanti kuyabulawa.
The investigations are ongoing, and release of the applicant may jeopardize further investigative steps. Releasing the applicant on bail will therefore undermine or jeopardize the public confidence in the criminal justice system.
Futhi-ke apho-ke uyatsho into yobana-ke xa ungakhutshwa ke ngebheyili ingabe kanti-ke loo nto leyo ibonakalisa into yobana uluntu ngokubanzi angeke luthembeke emthethweni.
And relevant case law on paragraph 35, relevant case law. In State versus Botha 2002, volume SACR 222 and SCA, the court held that Schedule 6 matters, the accused bears a heavy burden to show exceptional circumstances justifying his release. And in S versus Peterson in 2008, volume 2, SACR 355C, the court emphasized that exceptional circumstances must be truly unusual and that serious offenses involving interference with witnesses weigh heavily against the granting of bail. And in Tlantla SGP and reported case A07 of 2023, at paragraph 5, the court held that the applicant must present cogent evidence that will be able to stand up to scrutiny in order to convince the court on a preponderance of probabilities that the applicant is a candidate for bail. And finally, on State versus Matebula 2010, volume 1 SACR 55 at SACR at paragraph 12. The court held that thus it has been held that until an applicant has set up a prima facie case of the prosecution failing, there is no call on the state to rebut his evidence to that effect. He, that is the applicant, must prove on the balance of probabilities that he will be acquitted on the charge.
Njengokuba ke echaza ke izicatshulwa amatyala ke axoxelwa ngaphambilini asetyenziswayo kumatyala njena ke nangona ngumntakanika uyatsho ke ukuba ku-S versus ubhota iyatsho ke into yobana funeka uzise ubungqina obubonakalayo nobungathandabuzekiyo into yobana wena ke ufanele umthetho ukuba ungakhulula uxoxele ityalo ngaphandle njengoba esitsho napha ku-S versus Peterson uthi ke obo bungqina funeka bube bungqina obungaqhelekanga nobuzawuze enkundleni noba kungabe buyajongwa na bubonakale bubungqina obukulungeleyo into yoba kungathi bamamenyelwe uthathwa kuziswe enkundleni ube kanti wena ngaba ngumntu okhululwayo uxoxela ityalo ngaphandle ukuthi ke nobo bungqina uza nawo funeka bube bungqina obukulungeleyo ukuthi bungaphekwa busophulwa ukuze buphengululwa kujongwa into yoba ingaba bubungqina bobubona uthi ke lezo zinto zizinto ezingakubangela into yobana umthetho ukubone into yoba ukulungele into yoba ungabe kanti uyaphuma ngebheli.
In conclusion, in paragraph 36, Your Worship, in the circumstances having regard to the seriousness of the offence, the strength of the state case, the status of the deceased as a witness who testified before the Madlanga Commission, and who was likely, again, Your Worship, application to amend, there was a two was, can we just have one was? In the circumstances having regard to the seriousness of the offence, the strength of the state case, the status of the deceased, as a witness who testified before the Madlanga Commission, who was likely to give crucial evidence in a criminal proceeding that could have resulted in a prosecution and possible imprisonment of influential persons. I strongly oppose the granting of bail to the applicant. I therefore submit that the applicant failed to demonstrate exceptional circumstances exist that warrant his bail, released on bail. It is accordingly in the interest of justice that the applicant remains in custody pending the finalization of the trial.
Uthi-ke imeko ke njengetyala elinobuzaza kakhulu kangaka kwakunye ke nendlela ebufe ngayo umfi njengokuba ebengumuntu ebebaluleke kakhulu kuleya komishina kaMadlanga enikeza ubungqina uthi ke nangendlela le ekwenzeke ngayo ekubangela into yobana ekubana ngabe beqhubekekile nokunikeza ubungqina bekungaphuma phaya kulaa komishina kaMadlanga umuntu oye babe kanti uyafumaneke netyala abe azibone esekuvalelweni uthi ke ngolo hlobo uthi uyabona into yobana ke kanti uyayema into yokubana ke akavumelani nento yoba ube kanti uyakhutshwa uyaxoxa ungaphandle kwezityalo uthi ke wena ke woyisiwe ukuzisa apha enkundleni into ebonakalisayo into yoba ukulungele okanye ukulungisa komthetho ukulungele uba ungabe kanti uyaphuma ke wena ngebheli uxoxe ityala ungaphandle uthi ke cela kuhlale ngaphakathi uze ke ityala ufikelele emntwini.
That concludes the affidavit of the investigator, so that was duly signed and commissioned on the 18th of May 2026. I believe I have handed in the copy of the affidavit, may be marked as Exhibit B.
Exhibit B, thank you.
Yes, the court pleases.
Will that be the respondent's case?
That will be our case, Your Worship.
Okay, thank you. And as agreed at the beginning of these proceedings, we will postpone the proceedings that will enable the applicant defense to deal with the additional counts from 8 to 16 in their report. And the date arranged is 21 May 2026, the coming Thursday. You may stand up, sir. Then your matter is postponed until 21 May 2026 for a further hearing of the bail application or remaining custody in Merwe.
Tyala komphikazi umise umhla we-21 kaMeyi komkhuzo sokuqhubekela simamele isicelo sakho sebheyili njengoba ke ikhotho limelele lilungise okuthile ekufanele lilungise apha enkundleni nento yobana ke uzohlala uphakathi kwamele ukufikela i-21 kaMeyi 2026. Understood.
Please stand down.
That is the role, I believe, Your Worship.
Thank you.
here before I forget. Implementation of address.
What are you writing?
Modifications of the identities of argument which did not mention the employment and the address of the wife. What is the mention that is going to be detrimental to them? What else did you not mention that is going to be detrimental to them? Those are the two things.
Thank you. Then the court is adjourned.
You must pay me for doing your job.
No, you should thing is a thing like. Yeah, for doing my job. Get to go figure out.
I'm a paper. Later on. Yes, yeah. And you are coming on Thursday. Yeah, they will get them on Thursday.